I request Mr. Robert L. Stoll, partner, Drinker Biddle and Reed, and former Commissioner for Patents, USPTO, to address the distinguished participants.
Good evening, ladies and gentlemen. It's a pleasure to be here. I've actually got a slightly different job this evening. I want to thank Mr. Agrawal for inviting me to come and speak again. Like our previous speaker, I've been here before, and I really enjoy these conferences because I think a lot of collegiality and ideas are exchanged and help all of us to improve our systems. I'm here tonight with a different task. I'm to talk about the America Invents Act, and I will try to go through it fairly quickly because there's a lot to it. I may skip slides, but know that you will be able to access my slides, and you can email me if you have questions later on, and I'll be happy to answer your questions about the Act. I'm going to tell you my kind of ideas with respect to this Act. I think that they are ideas contained in the changes that are going to be applicable to offices around the world, and I'm going to also talk about ways of moving your applications more quickly through my office and through other offices. And the reason I'm fairly capable of talking on this topic is I was the Commissioner for Patents when this Act passed. So I'd like to get right to it. On the day that the Act was signed, that's September 16, 2011, I was in the room and I actually met President Obama after he signed the Act and talked to him a bit about it. He's a very strong supporter of intellectual property rights. But as of that day, those first series, that first block, became effective in the morning. So the minute his pen left the paper, I emailed my 8,000 examiners and said, you need to change the way you're practicing already because things are different now that this Act passed. And I'll go through some of them so that you understand what's happening in the United States. We were the last holdouts with respect to best mode, and now this Act, as of that date, no longer allows for the invalidation of a patent based upon failure to disclose best mode. And while you're going to hear a lot about that in the United States, I'm going to say to you, I still think that the attorney who practices has an obligation to deal with honesty before the office, and I'm advising my friends to include best mode. So while that change was made, I don't think you're going to see much of an effect. We had this idea in the United States with respect to virtual and false marking. Folks put the patent numbers on their products, some of which expire. There was a movement to take an action qui tem, meaning an attorney can stand in the place of the Justice Department and go after these guys. Most of these problems were not something that were intentional, and it was causing a jam in our system, so we got rid of the problems with respect to virtual and false marking. There were some movements with respect to human organism prohibition. I don't believe that there is any significant change in the PTO. We never actually patent a human organism, and I never expect that we will. So you'll see that these roll. They're not all effective in the same time frame. And the reason being is it's very difficult for my staff to implement all of this at once. So we've got things moving as time goes, and we can put out regulations for being able to handle these patents. The next 10 days later, we had a 15% fee charge come in place, and then we had a prioritized examination. I think that's going to be something that many other offices are looking at and may implement themselves. And I'll talk more about that. We had 2 more days, not big changes, and then we get to September 16th, 2012. And I believe that's where the meat and potatoes of the actual Act are. You'll see many things